May it please my lordships.
Yes.
Lordship, I beg to mention item number 21. In the last occasion on 12/3/25, it was fixed on 9/4/25. However, my lordship, Justice LS was here.
Okay.
It was against his order.
Okay.
So it cannot be taken up. So the learned senior counsel informed me that since there was no fixation, they have due holiday and on holiday. So to kindly fix it on 28/5/2025.
28/5.
28/5.
28/5.
Yes, I was.
28/5 is a Monday.
Oh,
That is what
28/5. No, 28/5 is a Wednesday.
28/5. Yes, sorry.
28/5 is Wednesday. Correct.
But can it be on 21st?
No. Wednesday. 28/5.
21st, May 21st.
20. You cannot change the date. You, madam, when do you want it? When do you want it? 28.
Wednesday, 28 is Wednesday.
Huh.
Since they are outside lawyers, I was instructed to fix on 28.
Okay. On the request made by MS Zajimomi, learned counsel for the petitioner, the matter is listed again on 28/5/2025. Okay.
Obligation.
Lordship.
Yes, Mr.
Lordship, I beg to mention hearing item number 16, 17, 18, and 19.
16, 17, 18. Yes.
And 19.
16,
Your Lordship,
17.
here regarding the chapter 4A of the laws of administration, we have already obtained the action of the governor. And now within this week, we are going to notify that thing. That is other part.
So if chapter 4 is introduced,
Yes.
what will be the fate of this revision petition? Whether that will satisfy the prayer made in the civil revision? And that's the-
Lordship, that is one part. And another part is in order to meet all those issues involved in the analogous cases. And we have already submitted a proposal to the government to constitute a committee to see all those, to meet all those issues involved in the present analogous matters. So we pray for some more time,
Okay, you place the up-to-date status report next date.
Lordship.
Okay, let them place up to the, because actually what I feel is chapter 4A. With the bringing in chapter 4A, I think that may not answer the issue raised in the civil revision petition. That is the apprehension this court is. Anyhow, you just place the up-to-date status report.
Lordship.
Let us, okay? How much? How much time?
After 4 weeks.
Up to 4 weeks. On the prayer of Mr. M.T. Imsum, the learned additional advocate general, listed after 4 weeks for enabling the learned additional AG to place the up-to-date status report in the case. Okay, listed accordingly. Yes,
Item 19, that's the interim.
item 19.
Lordship.
Yes, item 19, ma'am. Item 19,
Time for
the
the interim continue, Lordship.
interim order passed earlier shall continue till the next returnable date. Okay,
Lordship, Lordship.
Yes.
Lordship, I'd like to mention item number 11, Lordship. 11. 11, I'm for the respondent, Lordship. Lordship, let this matter come up after 2 weeks, Lordship.
on the prayer of Mr. Fuseko, the learned counsel for the respondent, list the case after 2 weeks.
Lordship. Bless me.
May I please lordship?
Yes,
My lord, on behalf of Vizamami, I beg to mention item number 8. He has requested your lordship to list the matter after 2 weeks, my lord.
on the prayer of Mr. V. Jimomi, learned government advocate, listed after 2 weeks.
Yes, ma'am. Much obliged.
Yes.
Please, your lordship,
Yes.
I beg to mention item number 12, hearing item number 12.
Ah,
My senior has some personal difficulties today, so lordship may kindly allow to this matter after a week.
MS so-and-so. Learned counsel for the appeal submits that Mr. Joshua Shakti, the leading counsel, has some personal difficulties and therefore seeks adjournment of the case up to 2 weeks. Prayer is allowed, listed accordingly.
Much obliged.
Yes, Mr. Lordship.
Yes.
To mention item number 20.
Ah,
Yes, I have received a letter just now.
okay.
Lordship,
No, you place it in the form of an affidavit. It cannot
just
just,
for-
no. Affidavit you place.
For 2 weeks time because they are under consideration. We consider the BS.
Mr.
Lordship, for 4 weeks time.
Young Rawati, learned counsel, learned CGC submits that he has instructions from the respondent / Union of India to seek adjournment of the case for 4 weeks. For what?
2 months, Lordship.
For what?
Lordship, they are seeking instruction for the BBC whether the course is.
To place the up-to-date instructions. To place the up-to-date instructions in the matter before the court. Listed accordingly. Okay.
Lordship, 4 weeks.
No.
Because they are under consideration with
No.
BSc.
I think we have given 4 weeks. How we have given 4 weeks?
Lordship, it says 2 months. In the letter, Lordship.
Don't try to take undue advantage of the court's generosity. Okay. 4 weeks. Nothing more, nothing less.
Lordship,
Yes.
Lordship, I beg to mention item number 15.
Yes.
Yes, Lordship, I have taken the consent of the opposite party, so Lordship, I pray this matter may be listed after 1 week.
Lordship, I'm here for the respondent number 1.
Okay.
Yes, next.
On the
week,
prayer
Lordship.
of MS V. Socrates, learned additional AG, listed after 1 week. Okay.
Well, Lordship, again, item number 22, 23, 24, and 25, your Lordship. Here also, I pray that this matter may be listed after 1 week.
On the prayer of,
Your lordship, if the matter may come up after 2 weeks, my senior is indisposed that week.
on the prayer of the learned counsel for the parties, listed after 2 weeks.
Much.
Please, Lordship.
Yes.
I beg to mention item number 13 on behalf of Tagakichi Lordship.
Yes.
This matter may kindly be listed after a week as the council has personal difficulties today.
Mr. Sensor makes a mention on behalf of Mr. Takakichu, learned counsel for the appellant.
Respondent,
Makes a mention on behalf of Mr. Takakichu, learned counsel for the respondent,
number 17,
and seeks adjournment of the case for
1 week.
a week. Prayer is allowed, listed accordingly. Okay.
May I please, Lord?
Yes.
Lordship, I beg to mention hearing item 7, Lordship. Lordship, on the last occasion, there is 2/4/2025, Lordship. The learned CJC has prayed to the court that there is a similar matter pending before the SLP. So, Lordship, if this matter.
What is that matter?
Yes, my lord, regarding the population census panel.
You have never brought that matter to the notice of this court.
Yes, my lord, on 7th April of this year, 2025, I have placed that this record this honorable court.
So what is your prayer?
My lord, I didn't get case is pending at the Supreme Court, so that
Any material to show?
yes. In previous occasion, I have placed this record at the honorable court. And this present case is also reflected, referred to that looks a village and to your village, my lord. And that case is pending in the Supreme Court, my lord.
Mr. Zatanguli. Learner CGC submits that. Similar case is pending before the Honorable Apex Court. In petition for special leave to appeal, within bracket C and O within bracket S 11595/2017. Stop. He therefore submits that the present case may be listed after the disposal of the SLP by the Honorable Apex Court. Prayer is allowed. List the keys after the disposal of the SLP by the Honorable Apex Court. Okay. Much obliged. This, brother, just wait. This, I think that's, this, Item 9 and 10 next week. Okay. Item 9 and 10, Mr. Puseko. Item 9 and 10 next week.
Kui kirat nang laga ketungarai kui amang sampai mo.
Minutes. Item 9 minutes. Your lordship may take it up today only minutes. Because next week will be difficult otherwise.
No, next week. I think next week will be the right bench to take up the. We are listing it next week, ma'am. Next week will be the right bench.
Ma'am.
Yes, because next week on which I see, minutes. I understand.
Next
So which
week-
date, minutes? Which date is your lordship keeping?
Next week, Wednesday.
Very well. Yes, minutes.
My lords, I am for
Very-
item number 10, my
Very
lords.
well, minutes.
Okay, next week,
Yes.
what is next week? 21.
23rd, I believe your lordship is. 23rd, minutes.
Okay. Listed again on 23/4/2021.
Maybe Lordship, if my senior's name and
Yes. And minutes.
That's all right. That's all right. That's all right. Next week.
Very few submissions you have to make. Yes, yes.
Okay, next.
Minutes. Yes, my presence will be noted, minutes.
My lords, I am for item number 10.
Minutes, my presence will be noted.
Please kindly take the names and give it to
Yes, Advocate Seth Vidya, I have already dropped the message.
you give your names to the
Minutes,
local
Pinky Anand, for senior advocate.
motion. I
Yes,
think
minutes, they've been given, minutes.
Please close it.
Yes. Grateful,
Obliged,
minutes.
my lords.
Please, your lordship. Your lordship, here the petitioner is approaching this honorable court for setting aside the impugn order dated 15/1/2025 issued by the special secretary lordship.
Heard, Mr. Senso. Learned counsel for the petitioner. By filing this petition, the petitioner is impugning the detention order number, all capital CON/PIT/NDPS/01/2025/16 dated 15/1/2025, issued by which respondent?
Issued by respondent number 2, lordship.
Issued by the respondent number 2. Any new, this, whether the detention order has been extended?
No, lordship, no, lordship.
Whether MS Livika, learned government advocate, shall on the next date obtain necessary instructions as to whether the order dated 15/1/2025 detaining the detainee has been extended. Listed again on next Wednesday. Listed again on 23. 23/4/2023. Kindly get instruction. Okay. Much okay.
For motion, item number 2.
May I please, your lordship?
Hmm.
Lordship, the petitioner has preferred this petition against the order dated 28/3/25 of the Honorable Central Legislative Tribunal Constitution. Now, lordship, what happened? Actually, this article is very small, lordship. He opted for choice posting by virtue of completion of his tenure in the northeastern region. In terms of the revised choice posting.
Why are you impugning this order? Why? What is the reason?
The order is otherwise in my favor.
Ah.
To the limited extent that lordship, there was an interim order operating in my favor that one post of assistant general manager at Jaipur may not be filled up during the.
So you want, by filing this petition, you want this court to regularize your interim order? How is it possible?
I'm only paying that lordship. The tribunal at the end of the judgment held that I am duly eligible and entitled
Ah,
to choice posting.
correct.
But the tribunal again gave me liberty to submit fresh choice, fresh.
So submit,
So, but
submit.
this will be perhaps the 6th time I'll be submitting choice.
So what? There is a direction from the tribunal. If you're asked to submit, you can submit. That's all for your choice posting.
But there are already 6 times, 5 times.
So what?
And lordship, the interim order regarding Jaipur was already operating. And it was interim order for Jaipur was.
That interim order merges with the final order. So that interim order is no more there.
No more there. So that is my difficulty, lordship, against the right approach. So lordship.
Mr. So-and-so,
Lordship may hear me for 2 minutes.
learned counsel for the petitioner. By filing this petition, the petitioner has impugned, where is the impugned order?
386.
Has impugned the order dated 28/3/2025. Please wait. Passed by the honorables, passed by the learned CAT, Gauhati bench in OA number 79 of 2024. To the extent of directing the respondents to consider and accommodate the petitioner at any place of his choice posting, namely at Jaipur, Delhi, Jaipur/Delhi/Lucknow/Hisar/Ambala. And also the impugned letter is dated 28/7/2023, 18/9/2023, and the speaking order dated A1/8/2024. Issue notice to the respondents returnable after 4 weeks. The learned counsel for the petitioner shall take steps for service of notice upon the said respondents by registered postbid AD within 3 days from today. Okay. You cannot have your choice of posting as per your whims and wishes. Yes, next. Next. Okay,
For
next.
admission, item number 3.
Yes.
May I please, your lordship?
Huh.
Lordship, I'm appearing for respondent number 3, lordship. By order dated 19/12/2025, the respondent number 3 was directed to give the up-to-date status of updating
Yes,
the
where is that up-to-date status?
Lordship.
You
So,
want to submit through VC?
Lordship, I've received a verbal instruction only, Lordship. So if I may be allowed to file in affidavit up to date the status, Lordship. So there are about 3,650 uploaded after the 19/12/2025, Lordship, from across the district, Lordship.
You are the counsel for the?
Respondent number 3, Lordship.
On the prayer of MS Apila Sanktam, the learned counsel for the respondent number 3. The matter is adjourned for.
Lordship, if I'm in 3 weeks, Lordship, to at least
Matter is
to
adjourned for
file
3
the
weeks.
affidavit, Lordship.
To enable the learned counsel to file affidavit placing the up-to-date status report as directed by this court by order dated 19/12/19/2025.
Right, Lord. Obliged, Lordship.
For admission, item number 4. Yes. Control of the documents. Yes. See what the subject. Yes.
The beginning, Mr. Shiba was elected out then 7/24. In the record, I annexed the FIR, which is in page number 32, annex 3. Page 32. The FIR was written by the assemblies. If the lordship is valid, I will read out for you. This is the officer in charge, Dimapur Police Station, Dimapur, Nagaland. First information report. Based on specific input read from our own source regarding likely movement of truck consignment on New Lane, Dimapur Road. Number 2. On 10 July 2024, around 22 hours, motor vehicle checking party, so and so 43 Assam rifles, along with police representative sub-urban base was launched and new general area of New Lane Dimapur Bridge. Around 23 hours, a vehicle Hyundai so and so was intercepted. On searching the vehicle, 3 individuals were found in possession of 81 soap cases of sunflower drops, suspected to be heroin. Number 4. The details of apprehended persons are: number 1, Mr. Kampai Kunyak, son of so and so. Number 2, Apo Chipa, who is the present detainee, my lord. And number 3, Kampai Kunyak. Thereafter, the last paragraph. Details of recovery, which is there annexed in the table. Then number 6. Apropos above, it is requested that detailed investigation be carried out in your end and suitable charges be framed against the individuals for possessing and carrying out illegal economic drugs. My lord, thereafter, the detainee was kept in judicial custody and was served the detention order, the immediate detention order, and detained under the Big NDPS Act under subsection 1 of section 3 of the Act by order number so and so dated 7/8/2024, which for an initial period of 3 months, which I annexed in annexure 4, page number 33. In the fact of page 34, page number 34, Your Honor. It is written that pursuant to the opinion of the advisory board, there is sufficient cause for detention of the detainee under the Pit NDPS Act 1988. However,
Where are you reading?
oh, however, this one is in the confirmation order,
Which page?
page 136, Annex 5.
Page 136?
Yes, madam. Annex 5, the confirmation order subsequently.
There is no page 136.
Page Annex 5.
Page?
Page 36, I'm saying page 36. Annex 5, the confirmation order, which was issued by the Special Secretary to the Government of Nagaland. My lord, may I come to this paragraph 3? Paragraph 3 of the confirmation order. And whereas the advisory report is of the opinion that there is sufficient cause for detention of the detainee under the Pit NDPS Act, this NDPS Act of 1988, and that the continued detention of the detainee, Mr. Apot so and so, will be necessary in order to prevent him from further indulging in illicit traffic in narcotic drugs and psychotropic substances without warranting his detention under the preventive law. Thereafter, the confirmation order was served upon him. My lord, after receiving the confirmation order and the detention order, the detainee has written representation to the authorities, which is in Annex 6, page number 37. I have written my representation to the Chief Secretary, to the Joint Secretary NDPS, number 3, the Chairman of the Pit NDPS, and the Special Secretary form on 16/1/2015, the date that they were served, and 30/1/2015, and 13 of January 2025. My lord, shall I read it out for you? My representation. Number 1, paragraph number 1, my lord, that I was page number 37. That I was arrested on 10/7/2024 in connection with people bar so and so, case number so and so. Number 2, that sir, accordingly, on the proposal of the additional DGB law and order, Nagaland, the Special Secretary to the Government of Nagaland issued detention order against me by so and so under subsection 1 of section 3 of the Pit NDPS for initial period of 3 months until now I'm under detention period. Number 3, that sir, I have been issued the confirmation order dated so and so issued by the Chief Secretary to the Government of Nagaland. The relevant portion is, and further order that I shall be detained for another 3 months with effect from so and so till 17/2/2025, within which period his detention will be reviewed as required under the provisions of the Pit NDPS Act 1988. Number 4, that sir, however, the said detention order dated 17/8/2024 and confirmation order dated 18/11 is liable to be revoked and set aside on the following grounds as under. Number 1, for that I have been implicated in the instant case on mere suspicion, as there is no prima facie material evidence against me. Number 2, for that even in presumption, though not admitting that I am involved in the instant case, then also imposing such deterrent law under me under Pit NDPS is not attracted considering the nature of facts and circumstances of the case. Number 3, for that the provisions of the Pit NDPS have not been complied with, particular section 3 of the NDPS while in or after issuing the said detention order against me. Number 4, for that I'm not an individual criminal, nor there is any past criminal antecedent against me to attract such preventive detention law on the Pit NDPS, which is one of the factors to attract such deterrent law. I am also not a convict in any such case in the past. Number 5, for that the grounds against for issuing detention order against me are security of the state of Nagaland and for maintenance of public order. Thus, it is not understood as to how I breach the security of the state of Nagaland and cause public disorder or the economy of the state. Thus, it is beyond my understanding that how could be I possess threat to the security and safety to the state and particular to the economy in general. Number 6, my lord. For that, the preventive detention law should not be exercised in a routine manner, considering the allegations leveled against me in the same case, as no incriminating materials were recovered. The offenses alleged against me can be tried by a regular competent court, and as such does not call for any. My lord, the next stage, preventive law, because by doing so it amounts to curtailment of personal liberty under Article 21 of the Constitution of India. Number 7, Governor, for that the prosecution has not established, accused or forwarded any incriminating evidence or documents after his arrest in any manner against the detainee which warrants and supports the detention of the detainee. Number 8, for that the detainee humbly begs to state that in the order dated 17/8/2024, which is the detention order, my lord, it is stated that whereas the ADGB, the additional DGB Law and Order Nagaland has sent a proposal for detention of Mr. Apod Shiba, so and so, 1988, along with records under Section 1 of the Prevention of Illicit Traffic and Narcotics, Drugs and Substances Act. Next paragraph. It also states that, and whereas I, Sunya Singh, Special Secretary Home, Nagaland, especially empowered under Section 3(1) of the Prevention of Illicit Traffic and Narcotics and Other Substances Act, as amended, I am satisfied on careful examination of the proposal of additional DGB Law and Order, Nagaland and other supporting documents found sufficient grounds for detention of so and so, and being satisfied that with a view to preventing him from engaging in illicit traffic and NDPS, it is necessary to detain him. The next paragraph, my lord. The above order states and mentions categorically and has reflected that the detainee has been detained on careful examination, along with records and supporting documents, which I made it in bold, along with records and supporting documents. However, the detainee only mentions that he has not been given or issued or has received any of the documents as mentioned in the order and which is mandated by law. The detainee humbly states that similarly situated detainees have received adequate explanation and large list of documents while the detention and confirmation orders are served upon them. As such, the detainee has inquired from the jail authority for such documents. However, the documents do not give, however, any of such documents to the detainee. The day of the detainee engaged a learned advocate to represent and appear on his behalf in the same case. The learned counsel came before the authorities on 2/1/2025, seeking for the additional documents of the detention and confirmation, which has to be issued and supplied to the detainee along with the detention and confirmation order. However, the authority could only issue the single page copy of the order dated 17/8/2024 and the confirmation order 18/11/2024. The authority could not issue any other document for the detainee as it doesn't have any other document except for the documents they have in the report. The detainee unalienable right to be informed on the grounds of detention has not been informed or explained to him in any as mandated by law. The right to make representation and information in communication to the detainee. The right to make representation against the detention order has not been explained, served, or informed to the detainee. The other documents such as FIR, arrest memo, station memo, proposal, or meeting minutes of the Supreme Court, proposal letter for detention, list of documents, statements, or witnesses, or any other documents as mandated by law has not been served upon the detainee, which is irreparable prejudice to the detainee and shall not stand the test of law. My lord, so as not to repeat again, to avoid repetition, I would like to come to the. By stopping, I would like to come to the affidavit filed by government, and which.
What are your grounds of detention? Kindly satisfy us. What are your grounds against the detention order?
That there are no compelling and cogent reasons to put me under detention. There are no compelling reasons and cogent materials against me to put me under detention. I'm in jail. I'm still in jail. I've not been given bail or thin bail. Then what is the need for me to put under this document law? I'm here in jail in custody for the last 8 months and 6 days. That is total for 6 days. I'm in custody, my lord. What is the need for me to give an detention again?
Any procedural lapses?
Yes, Your Honor.
What is that?
The procedure that I'm saying is, the paragraph 8, which I read it out to you, stating that I have not inserted documents. But to my surprise, I'm saying that affidavit that I have inserted documents, few documents, which is an affidavit of the government and page number 18. Affidavit of the government, made by the government, page number 18.
Are you not refuting that?
I'm refuting this because though I was made to sign, but I wasn't given the copy. I was given to sign.
You have received the affidavit filed by the government?
Yes.
Are you not refuting that affidavit?
I'm refuting this.
Where is your refutation by way of affidavit?
No, I'm giving by way of.
No, we don't accept verbal submissions.
Okay.
Okay, you submit, but that will be a minus point for you. Yes,
Your Lordship, I've submitted it in my representation that I've not been served the copies.
but they have actually made a statement that they have actually served you the copies.
And this representation that addressed to the authorities has not been addressed till today, except for the affidavit in opposition made by the government.
Okay.
Which, further, my lord, I would like to, if, coming to my page number 14, paragraph number 9. For that, the detainee further makes page number 14.
Okay, we stop with your representation. We want to know whether your grounds, give us in detail, supported by law.
Here, I would like to place on record, the decision made by the honorable court.
Your grounds first, thereafter the citation, your grounds first.
That there are no cogent materials and compelling reasons to give me under detention.
You take down the grounds. Questions. Yes.
Well, the detention authority has disclosed in the ground of detention that the authority has compelling reasons to believe that he is likely to be released, in the substance offense, either on bail or to this acquittal discharge. That is one of my grounds. And for this, I have powers decided by the honorable court. Number 2, for that there is no cogent material or compelling reasons against the detainee for the detaining authority to detention order.
See the grounds?
Page number 19. Grounds. Page number 19, come on, petition. May I read your honor?
Yes.
Page number 19, grounds. For that, the particulars in the detention order is nothing but inferential conclusions based on no materials whatsoever.
That is your submission.
Yes, Your
That is not the ground. That is your submission.
Yes. Number 2, for that, the detainee an inalienable right to be informed of the grounds of detention has not been informed or explained to him in any manner as mandated by law. The right to make representation and information and communication to the detainee. The right to make a representation against the detention order is also not been explained or served or informed to the detainee. The other documents such as FIR, arrest memo, seizure memo, proposal or meeting minutes of the Supreme Court, proposal letter for detention, list of documents, statement or witness or any other documents as mandated by law is not been served upon the detainee, which is irreparable, which requires the detainee and shall not stand the test of law. Thus, for this reasons, the appeal detention order stands vitiated and is liable to be set aside. Number 3, for the detainee is illiterate and while handing over the detention order dated 17/8/2024, the detainee was not explained in detail in the language he understands, and hence the order of detention is vitiated and liable to be quashed on this ground alone. He is a conduct, is an illiterate.
Okay, next.
Number 4, For the grounds of detention dated 17/8/2024 alleges that the detainee is strongly suspected to be engaged in illicit traffic and NDPs. The detainee denies this allegation. The said allegation is vague and not at all sufficient to detain the detainee under the Act. Furthermore, there is no specific allegation or materials pointing to the involvement of the detainee in illicit traffic and NDPs activities. Thus, for those reasons, the impugn detention order stands vacated and is liable to be set aside. Number 5. For that, the order of detention dated so and so mentioned that if the detainee is not detained, he is likely to indulge in similar prejudicial activities. Hence, the detention order has been passed to prevent the detainee from indulging in activities prejudicial which have a deleterious effect on the national economy. The detainee was already arrested and under police custody at the time of passing the detention order dated so and so. Therefore, there is total lack of application of mind on the part of the respondent number 2 when he concludes that the detainee has to be detained to prevent him from indulging in prejudicial activities. Since the detainee was already in custody and criminal case has been registered against him, there was absolutely no reason to further pass the detention order under the Act. At the next page, Your Honor. At the course of repetition, it is submitted that there was no necessity to pass the detention order when the detainee was already under police custody. Thus, the detaining authority acted without application of mind in on this ground alone. The detention of the detainee is liable to be set aside. Number 6. For that, the detaining authority has vaguely labeled illicit trafficking and NDPS allegations, NDPS Act allegations against the detainee. The allegation of illicit trafficking and NDPS against the detainee can be tried under the criminal laws of the land. The alleged activity of the detainee cannot be said to disturb the even tempo of the society, warranting the detention of the detainee under the preventive detention law. The activities against the detainee are matters of law and order and not public order as concluded by the detaining authority. Number 7, Your Honor. For that, a reading of the detention order and materials purportedly relied by the detaining authority for coming to the subjective satisfaction for detention of the detainee on the face of it reveals that the alleged activity of the detainee could by no means be said to have a bearing on the security of the state of Nagaland. Thus, the detention order is a transgression of the fundamental rights of the detainee guaranteed under Article 21 of the Constitution of India. For the activities alleged against him from indulging in activities prejudicial involving in illicit trafficking in narcotic drugs. Next page, Your Honor. Order is wholly without basis and liable to be indeferred by this honorable court. A police case has been registered.
Mr. So-and-so.
Yes, Your Honor.
Kindly make your submission on the basis of materials which you have enclosed. Kindly make your submission. These are grounds, these are more or less your submissions in the form of submissions. Before you forget about the citation, you first take us to the materials. You first take us to the materials which will show that the detention order is illegal.
Yes.
Yes, and then you go to the rulings, but you first show us the materials, which will show that you are saying that actually there is a procedural lapses. You are saying that there is no subjective satisfaction of the detaining authority. Satisfy us on that.
There's no court materials. There's nothing.
No, you show us from your petition. You show us what are the procedural lapses.
One of the procedural lapses, I didn't need to sign the documents that they brought before in the chair, but however, I was not able to cover the documents. It should be a thick book, usually issued to the detainees while giving the detention order. I was made to sign, but however, I was not given this documents.
That cannot be. You were made to sign, but you were not given.
Yes, normally
the document is for you. Therefore, it should be given to you.
Normally, it doesn't happen. This one rare case which I have also.
Yes, the other grounds. One ground is that actually the documents which were furnished to you, which on which you were made to sign, was not furnished to you.
Yeah.
What are the other grounds? That is to do with subjective satisfaction. Procedural lapses.
Procedural lapses. The first problem which I made, my lord, insufficient.
What is that procedural lapses?
The performance were not given to me.
Okay.
So I was made to sign, and on my inquiry, when I went into the representation to the authorities, asking for the documents, I still have not been issued. Number two, my lord, I am an illiterate person. I know the Punjab language and I know the Punjab script, but I was not given in the language that I know or in the script that I could read, which I could understand and comprehend properly.
No, if actually the grounds of detentions, if that was explained to you, why should the authorities retain the documents? Why should the authority retain the documents if it was read over to you? No, it is not your grievance. It is the question from the court. You are saying that actually the grounds of detentions were read over to you in a language not understood by you. Correct? So why should the authorities keep back the documents? Okay. Assuming we accept that the grounds of detention were not explained to you in a language which you understood. Okay, we suppose, assuming we accept that, why should the authorities retain back the documents?
The detention order.
We do not find any.
And my lord, please come to my detention order page number. Detention order which is in annex and page number annex 4, page number 23.
Huh?
Yeah, the date is 7 August 2024. The order issued is 7 August 2024. Then if you come below to the side, it is also showing us 27. That is after a lapse of around 10 days. Very surprisingly.
Nothing surprising. Okay.
It should be a
1710, 2710.
yeah, it should be within the period of 5 days. This is the first order detention order it was issued. The first detention order initiated before the confirmation order. So if we put the section 3 and 3 of section 3 plus 3 of the State Independence Act, it should be within the period of 5 days. That is one blatant and glaring violation. That this copy is to me.
Yes, madam. This 17.8 and 27.8. Can you kindly explain? Page 33.
In my paragraph 20, I had responded by saying there was no question.
No, you are saying that, but actually the documents you submit on the basis of the documents. What does section 3 says?
The registration on 28th of August, Your Lordship.
That is why 17 August it was signed, correct? 28. So after 17 and 27, that will be 10 days. Just see. 20. Okay. You have the records. Okay. Yes, continue. We will check the records afterwards. Yes.
one of the problems that I've made is the detaining authority issued the detention order in the sense case on the opinion of themselves. That we call exit exit, but not on basing on any material evidence or any coaching reasons. It was based the detaining authority issued the detention order exit exit.
That is to do with subjective satisfaction.
Yes, that's the section. But here in this case, since it is a draconian law, this is a very harsh detention order. It must be a definite order. It not be pressing on the opinion of one person or one side where there is no evidence or question reasons. So this is exit, and the other reason is it is on the hearsay statement of the accused person.
How do you say that the subjective satisfaction of the detaining authority
because the
is
detaining
improper?
authority issued this is a detention order on the recommendation of the ADHP law and order, but without any documents or without any studying material or without any reasons or without any evidence, he issued this detention order, basing only on the recommendation of the.
That is your
ADHP law and order.
submission. They have the records.
And for the records which they have, I am already in custody under the special law of NDPS Act.
That's all right. That is a ground. But only on that we cannot quash the detention order. Satisfy us.
I cannot be and the other ground that I made here is in my petition that there is no whisper in any manner by the detaining authority as to whether there is eminent and reasonable fear that the detainee shall involve in such act unless the liberty is curtailed and confined under detention. There is no such grounds has been made by the detaining authority while issuing the detention order against the detainee in this case.
Yes.
My lord, I'd like to place some more powers
Yes.
which is Abhimabhima.
Yes. 2023. Which paragraph?
28, you know.
Para 28. Yes, para 28.
I will read out.
Yes, please.
In the circumstances of a given case, a constitutional court, when called upon the test of legality of orders of preventive detention, will be entitled to examine whether 28(1) the order is based on the requested satisfaction, albeit subjective, of the detaining authority, or for the absence of such satisfaction as to the existence of a matter of fact or law upon which validity of the exercise of the power is predicated, would be the sine qua non for the exercise of the power not being satisfied. 28(2). In reaching such requested satisfaction, the detaining authority has applied its mind to all relevant circumstances, and the same is not based on material extraneous to the scope and purpose of the statute. 28(3). Power has been exercised for achieving the purpose for which it has been conferred, or exercised for an improper purpose, not authorized by the statute, and is therefore ultra vires. The detaining authority has acted independently or under the dictation of another body. 28(5). The detaining authority, by reason of self-created rules of policy or in any other manner not authorized by the governing statute, has disabled itself from applying its mind to the facts of each individual case. 28(6). The satisfaction of the detaining authority rests on materials which are of rationally probative value, and the detaining authority has given due regard to the matters as per the statutory mandate. 28(7). the satisfaction has been arrived at bearing in mind existence of a life and proximate link between the past conduct of a person and the imperative need to detain him over a space on material which is style. 28.8. The grounds for reaching the requested satisfaction is are such which an individual with some degree of rationality and prudence would consider as connected with the fact and relevance to the subject matter of the inquiry and respect whereof the satisfaction is to be reached.
Yes.
28.9. The grounds on which the order of preventive detention raised are not vague but are precise, pertinent and relevant, which with sufficient clarity inform the detainee the satisfaction of the detention, giving him the opportunity to make a suitable representation. And last 28.10, the timeless as provided, the timelines as provided under the law have been strictly adhered to. My lord, 29 as well.
Yes, how is this citation relevant to your case? Explain.
My lord, 28.9. This comes 28.9.
28.9.
The grounds on which the order of preventive detention rests are not vague, but are precise, pertinent, and relevant, which with sufficient clarity inform the detainee the satisfaction for the detention, giving him the opportunity to make a suitable representation.
Wow.
I don't need that document with me. I was not
Okay.
issued the document to make a suitable representation, my lord.
28.9. So you are saying that actually this clause 28.9
Yes,
was not complied in your case
yes, yes,
because the documents were not furnished to you.
yes. I was made to sign, but it's not given to me.
You were meant to sign the documents,
Yes.
but the documents was not furnished to you.
Yeah, only when the affidavit was filed by the government.
Whether actually the authorities concerned, they had actually explained the grounds of detention to you.
Oh, it's told us it's explained in Nagamis, but not in script.
It was explained to you in Nagamis.
Already in Nagamis.
It was explained to you in Nagamis.
Yeah, I mean according to the affidavit of the government. But however, I was not explained to me in Konyak language or in Konyak script.
Not necessary. You are a Naga. The documents will be furnished to the that actually explain the grounds of detention to the it is very questionable that this is very should be due also include the same to that. Why not give it to them? So I think the solution. The government, I think the technique of the when actually they give the grounds of detention has been explained, it is the sufficient possible the function of the ground of income has been explained to the levels. Not the documents. The relevant documents are not that I think we accept that kind of solution. Okay. So this
Your Lordship.
just wait. In this citation, this citation 23. He says that this is relevant to this was not complied. Yes.
Your Lordship, may I read Bharat 29?
Huh.
Should the court find the exercise of powers to be bad or to be vitiated, applying any of the tests noted above, rendering the detention order vulnerable, detention which undoubtedly visits the person detained with drastic consequences will pull for pain and directed for righting the wrong.
Okay.
Okay, and my lord, and the same this thing, may I take you to paragraph 27, Your Honor? Which will also help my reading paragraph 27, which in this paragraph 27, you know. Your paragraph 27 is also been reflected in the judgment of King of Kiev.
You read your para 27.
Your Honor,
You read your para 27. You were referring to this. Read it.
it has been reflected recently in 25.
It's all right. That we will see it.
Be that as it may, gulling of the principles of law flowing from the relevant decisions in the field, our understanding of the law for deciding the legality of an order of preventive detention is that even without appropriate pleadings to assail such an order, if circumstances appear therefrom raising a doubt of the detaining authority misconceiving his own powers, the court ought not to shut its eyes.
That we well understand, but actually, like you are actually reading the judgment without actually being supported from the facts of your case. See, that is why. So judgments are judgments. There is no dispute about that. But the judgment has to support your case, and for that you have to actually like recite your facts as to why the judgment is relevant.
We are giving you another judgment.
So this let us be precise.
Okay.
2023-9 SCC 587. The judgment which you have first relied. Why is this judgment relevant?
My Lord, I think that the reasons for issuing for the reasons
28.
reasons for the detention for the detaining authority to issue the detention order, those must be the reasons.
28-9.
Yes.
28-9.
28-9. This the ingredients from 28-1 to 28-10. Those are the ingredients which will satisfy the detaining authority to issue the detention order against the detainee.
So that's why I'm saying which clause was not satisfied.
28-4 also. 28-4. The detaining authority has acted independently or under the dictation of another body.
No, this may not be relevant for your case.
They passed the detaining order on the recommendation made by the law and order ADGB.
No, that is the rule. That is the process.
There's nothing to show that they acted independently also after studying all the materials it came.
Subjective satisfaction should be on the basis of the materials supplied by the arresting agencies. We have still not clearly understood your case, in spite of you making submission for more than an hour.
This comes this 28-7. 28-7. The satisfaction has been arrived, bearing in mind since of a life enforcement link between the first conduct of a person and the imperative need to detain him or express on natural wishes.
Okay. You are trying to read judgments without satisfying us with the facts in support of your case. That is the issue.
My Lord, I've submitted that the provisions under bid investigation 3 and 3 has been violated against.
That's why.
That's why.
Okay, just wait. Section 3. Okay, PNDPSA. There should be 2 books.
The article.
This is prevention of medicine. Section 3. Yes, section 3.
Yes.
What is the violation in section 3?
For the proposed, may I read? For the proposal clause 5 of Article 22 of the Constitution,
Power to make order detaining certain persons.
Yes, my lord. Your Honor.
Section 3.
Yes, clause 3. Section 3, clause 3, Your Honor.
This section 3.3 has been violated. So your submission is that section 3.3 has been violated?
Yes, Your Honor.
Okay.
Read article 5, clause 5 of article 22 of the Constitution. Read clause 5, article 22 of the
You first read section 3.
Okay.
I think you should know how to make precise and good submissions. We are not satisfied. Yes, may I read 3.3.
Clause 3. For the purpose of clause 5 of article 22 of the Constitution, the communication to a person detained in pursuance of a detention order of the grounds on which the order has been made shall be made as soon as may be after detention, but ordinarily not later than 5 days, and in exceptional circumstances and for reasons to be recorded in writing, not later than 15 days from the date of detention.
Okay. Okay. So this was not complied with. 3.3 was not complied. How?
I was made to sign the documents, but the documents were not given to me, not handed over to me.
Yes.
And the document which is handed over to me was the detention order, which is marked as 27 after the period of around 10 days, which I have annexed in my petition.
The communication to a person detained in person.
In which number 33.
Which shall be made as soon as may be after the detention. The detention or grounds. The communication to person detained in pursuance of the detention order shall be made. Okay. Where have you stated in your petition?
First, I stated that in my representation, Your Honor.
Where?
My representation is in page 37. Page annexed 6. Page 37. And I have mentioned that in para 8, which is in page 39, Your Honor. I have categorically explained and mentioned these my grievances to the authority.
In which para?
Para 8 and para 9. Particularly para 9, Your Honor. I've categorically addressed these grievances to the authority. In the hope that they'll come and they may come and issue me.
So you are submitting that your representation in para 8 and in para 9.
Yes.
Explains the violation.
Yes.
Of the provisions of section 3.3.
Yes. And
okay. Yes. The next. The first is that on the procedural lapses, there is a non-compliance to section 3.3 of the Act.
Yes.
Correct. What is your next procedural lapses anymore?
Your Honor, for that, the authority has issued this detaining order at C6 of the detaining authority without any cogent materials or compelling reasons.
That is on subjective satisfaction.
Yes, Your Honor. That is on subjective satisfaction. For that, Your
Yes.
Honor, and the affidavit made by the government. And the affidavit.
Do you have any more citations?
Citations, I have many, Your Honor.
Yes.
Shall I?
On the subjects.
I'll put in the report.
Let the government like make submission on their affidavit. You make submission on your petition
Yes,
supported by the law.
yes, Your Honor. My lord,
Huh.
I have given a breakfast.
Huh.
Please come to Vara 13. Record.
Para 13.
Yes, Your Honor. The principle of personal liberty, Your Honor. May I read out? In our opinion, Article 22(3)(b) of the Constitution of India, which permits preventive detention, is only an exception to Article 21 of the Constitution. An exception is an exception and cannot ordinarily nullify the full force of the main rule, which is the right to liberty in Article 21 of the Constitution. Fundamental rights are meant for protecting the civil liberties of the people and not put them in jail for a long period without recourse to a lawyer and without a trial, Your Honor. Next, the imposition of what is in effect a substantial term of imprisonment by the exercise of executive discretion without trial lies uneasily with ordinary concepts of the rule of law. Article 22 hence cannot be read in isolation, but must be read as an exception to Article 21. Article 21. An exception can only apply in rare and exceptional cases, and it cannot override the main rule.
Yes. Explain this. Explain. Para 13.
What it here says that the liberty of a person provided under Article 21, which is a person cannot be sent to jail unless the procedure established by law. Though the Article 22 says that, though the Article 22(3)(b) says that there is power for the authority has the power to send for preventive detention. However, he must look into the factor of Article 21, which safeguards the protection of an individual as established as procedure established by law. So what I want to stress is that the alleged accused person who is here in custody as a detainee for the last 8 months and 6 days, around 146 days, he has been kept in detention without following the procedure as established by law under Article 21 of the Constitution.
And what is that article what is that procedure which has been violated?
Yes, though he has been made to sign the documents, but he has not been.
Okay.
I'm coming back to repeat.
We have understood that. Okay, next.
Next. My lord, may I read the article paragraph? Okay. In the same way, I want to read the article paragraph 21. Paragraph 21 in the same. Here it is, Your Honor. It is very well to say that the preventive detention is preventive, not punitive. The truth of the matter, though, is that in substance, a detention order of 1 year or any other period is a punishment of 1 year's imprisonment. What difference is to the detainee whether his imprisonment is full preventive or punitive? my lord, it's almost like a punishment. If he is kept in detention for 1 year without trial, this is not preventive, rather it's punitive in a punishment, your lord. That is a,
There is a law
yes,
which allows preventive detention for 1 year. There is a law.
yes, yes.
Only thing is that it should not be in violation of Article 21 of the Constitution of India.
Please attend, my lord, this comes to paragraph 23 in the same section. In this connection, criminal cases are already going on against the detainee under various provisions of the Penal Code 1860, as well as under the Drugs and Cosmetics Act 1940. And if he's found guilty, he'll be convicted and given appropriate sentence. In our opinion, the ordinary law of the land was sufficient to deal with this situation, and hence recourse to the preventive detention law was illegal.
This will depend on facts to facts of the case.
Yes, Your Honor. So in our land also we have this NDPS case, which is pretty much prevalent. This is a special case. Even the accused can be tried in this, and he's in jail under this sections of NDPS.
What about the enactment of PINDPS?
Yes,
What about the object of enacting the PINDPS?
yes, to prevent illicit trafficking.
Yes.
But however, my lord, you should have cogent materials and
Okay.
competent.
Any more citation?
Okay.
Yes, next citation.
Yeah, okay, time to mind.
Sum up. One is that there is procedural lapses because of non-compliance of section 3(3)
Yes,
of the Act.
yes. And
The-
Article 225 of the Constitution.
That's all right. The second is that the person was the detainee was detained at the ipse dixit of the authorities
Yes.
without any cogent reasons. So there was no subjective satisfaction. Correct. These are the two grounds on which you want to assail the detention order. Okay. Yes, Government. Yes. Madam, do you have the records?
Yes, Lord.
Yes.
Five possible lapses from share.
Just wait.
We admit to your lordship and in my
Just wait. Yes, on procedural lapses, ma'am.
procedural safeguards has been strictly adhered to your lordship and in my affidavit, your lordship, paragraph 20, your lordship, I have never specific statement in your lordship.
Just wait in your affidavit.
Page 8, paragraph 20, your lordship.
Page 8, para 20, okay, just wait. Just wait. Para 20. This is regarding yes.
Your lordship, this paragraph will show that there was no violation of procedural provision of law, your lordship. I
Yeah.
think a lot to do here.
Please.
Paragraph 20. That the amendment made in paragraph such and such of the writ petition, the answering department states that there was no procedural lapses and all procedural safeguards have been strictly adhered to by the detaining authority and within the stipulated time frame as per the law. That as per the record of this office in compliance of section 3(2) of the PIT and PS 1988, the report of the detention was communicated to the central government on the same day of detention, that is on 7/8/2024, both by email and speed post. And as per section 3(3) of the Act, the communication of the detention to the detainee was made on 4th day of detention, that is on 28/2024, your lordship. The records will show, your lordship, that in compliance of section 9(b) of the Act, reference before the advisory board was met on the 7th day from the date of detention, that is on 23rd/8/2024. That as per section 9(c) of the Act, the advisory board submitted its report before the stipulated time frame of 11 weeks 77 days, that is on 2010/2024. The representation of the detainee was forwarded by central jail authorities to the central government both by email and by speed post on 10/1/2025 and 11/1/2025. The same was disposed of by the central government on 30/1/2025. Further, central jail authorities had forwarded the representation to the detainee to the advisory board by email and by speed post on 1/1 such and such respectively. Being such, has been no violation of procedural provisions of law. As such, the detention order passed by the dealing authority is just and need no interference. Your Lordship, with regard to
Ma'am, what should be the time taken by the central government from the time it receives yes, from the time it receives the detention order from the jail authorities? What time should the central government dispose of the representation? Kindly come to page 9, your paragraph, which you were just reading. Come to the last 8-9 lines. So, the representation of the detainee was forwarded by central jail authorities to the central government both by email and speed post on 10/1/2025 respectively. The same was disposed of by the central government on 10/1/2025. So, what should be the time gap for disposal of the representation by the central government?
days, Your Lordship.
20 days. Where have, yes. What is the law? What is the law?
One of the
After the central government receives the representation of the detainee from the central jail authorities, within how many days?
The definition of the review was basically from 10 July to and that one is disposed on the 30
1/2025. So is it within the time permissible?
But we're here to seek the paralyzed comments from the state government, so that after we do that, the paralyzed comments are going to go through all the technology.
No, that's why that is okay. But what is the duration the central government should take to dispose the representation? Because here governments are mad. So we would also like to know what time, what should be time duration within which the representation should be disposed by the central government. This is section 3(2). Okay. Okay, make submission. Okay. So on the grounds of this procedural lapses, you are supporting your submission with paragraph 20. Okay. Huh.
Submitted that only the detention order was served to me, but along with the detention order, all the annexures, relevant annexures were served to me, and in support of this, the para 6, Your Worship.
Para 6.
I have made a specific statement.
Para 6. That all the documents were furnished with the along with the detention order. Just wait. Yes, read your paragraph 6.
That with regard to the statement made in paragraph 5 of the writ petition, the answering respondent denies the statement that the detainee was served only a single page detention order, and further state that the records will show that the detention order dated 17/8/2024 passed against the detainee, Mr. Apashepa, along with all relevant documents were served to the detainee and acknowledged by the detainee on 28/2024. That the records will also show that the detainee had appended his signature in the detention order, grounds of detention, information to the detainee, and all relevant documents based on which detention order was passed by the detaining order authority against the detainee, indicating that all relevant documents were forwarded served to the detainee, not displayed.
Where is the record?
Your Worship, I should record it. I also like to take your Lordship to paragraph 16. Your Lordship.
Paragraph 16. On the same issue.
Page 7.
Paragraph 16.
Page 7.
Paragraph 16, correct? Page 7.
That the statement made in paragraph 21 of the writ petition, the answering deponent denies the same and further states that the reports will show that the information to the detainee dated 17/8/2024 as per section 3(3) of the PIND base 1988 for the purpose of clause 5 of Article 22 of the Constitution served to the detainee was acknowledged by the detainee, wherein it is clearly stated that the detainee had the right to make a representation against her detention to the detaining authority, state government, central government, and advisory board. Your Lordship, Annexure B, Your Lordship. This is the acknowledgement certificate, Your Lordship. Page 20.
The acknowledgement, just wait, just wait. Taking note of this. Yes.
Have turned your attention to the this annexure for annexure 4 of the writ petition, Your Lordship.
What does it say?
Yeah, the signature appended does not belong to the petitioner, Your Lordship. There's no signature And he's saying that it was received on 27.
Annexure,
Annexure 4 of the writ petition, Your Lordship.
annexure 4 of the writ petition,
It's page 33, Your Lordship.
page 33.
Yes, there's no signature of the petitioner, Your Lordship, saying that he had received on 27, Your Lordship.
Okay, kindly show us the records supporting your averments made in your affidavit in opposition on the compliance of the procedures. You 100 page
The signatures which had appended on all the enclosures.
230. There's a detention order. Grounds of detention.
The signature along with the date, Your Lordship. 28, 24.
The grounds of detention in the information to the detainee. 28. Correct. Then this is a proposal for detention of the accused. Proposal. 28. It is the proposal continuation. Proposal continuation. Proposal continuation. This is the minus of the screening board constitute to look into the proposal submitted under PNBC 28. Okay, and then this is the proposal for detention of accused persons, namely shippers and so. This is namely up it. Okay, there were three. Only one is before it. 28, correct. 129. 130. 131. Okay. You're saying page 1192 to 13. 1192 to 13. Yes. Yes.
Sorry, the confirmation.
There was no procedural access. Compliance to section 3. Okay,
So
yes, please.
This acknowledgement certificate which I saw on your lordships earlier, page 20, the signature appended is the same, your lordship.
Page 20.
Page 20. Even in the records, it's there. This acknowledgement certificate.
Reports page 119 to 213. Receiving the reports. Okay.
So with the lordship, with regard to there was. So these are my points
On the grounds taken by the petitioner that there was non-subjective satisfaction to detain.
The FIR, police report and the documents, your lordship. These are the actual facts and circumstances of the case, your lordship, based on which the detaining authority had formulated the grounds of detention, your lordship. And that's also with regard to the
Subjective satisfaction, FIR.
FIR, police report and documents, enclosures, the bank statement, there's a bank statement also, your lordship, in page 36, your lordship.
Page
36 of the your lordship, the reports which I have submitted, your lordship. In page 36.
36.
We'll start from page 36, the bank statement, your lordship. And
Page, madam, page 36 of the records. It's, I think, this is arrest memo. Page 36.
your lordship, but I have put a flag, and in the flag I have written the.
There are so many flags, numerous flags.
In the flag, I've written the details.
56.
Okay.
56.
And also, there's this bank statement tallies with the voluntary statement given by the petitioner.
Well, what has this bank statement got to do with the detainee?
The detainee had, on number of occasions, he had, smuggled the drugs. So this bank.
And made
statement-
transaction through
yeah,
this bank.
This transaction and the statement which had made will tell you, Your Lordship.
The statement of the detainee.
Yes, Your Lordship. And Your Lordship, it may also go to the advisory board report, Your Lordship. Your Lordship, when all reasons for passing the detention order has been stated in the detention order, Your Lordship. In order to prevent the detainee from.
Yes. Hold this up. We'll just take a break. Yes, ma'am.
When all reason for passing the detention order with a view to prevent the detainee to Your Lordship, I'm sorry, abating the detainee from indulging in prejudicial activities, Your Lordship. The subjective satisfaction to detain him prevails, Your Lordship. And in support of this proposition, Lord, I'd like to see a citation, Your Lordship. On subjective satisfaction.
This is on a subjective satisfaction. Yes, we'll raise up after 2 minutes.
I'll show you, yeah, I know. That's clear.
The representation of the country.
Here's the comedian errors. Yes, he signed, even he also he signed, nah. Because this is a trailer, nah, but this copy was given to my client one. This copy was given to Uchiba one. This copies must be given to him now, not in the build again. Instead of this copies, this must be given to him now. If this copy is supposed to be given to trailer. Which will target, we never go down. That's why he was signed, but it was not given to work again.
You know, how is it possible?
How is it possible? First time I'm trying this. I'm
But since
issue with now.
since you it was
Yes. See, then how long they gave me, this is my question, this is original copy. This is not the box. So even the chiller is still only on 7. That means. See, that's what I'm saying. I was given this copy, which is also not my copy. I'm in Z jail. I'm not able to access this document though. Confirmation of that agreement now. So confirmation is. Wait on. Ito general constitution. Where our fight is on this.
This is what I'm saying that. On confirmation, then we done something, not our own.
No. This one was when I wrote my representation in 4th January. This one. When I representation, I received this on 2nd January. Yes, from my client. I was engaged by my client. My client received this. Because no. I don't know which day he received, but he was given this copy. By the ION, on which yes, asking for other documents.
See, documents na meron na. Documents na meron na.
So I asked, so I went to the jailer, seeking for documents, the jailer was especially fine. So, então, é isso que você, todos já documents como todas as não, é isso que você aí vai dizer. Huh? Must be. Maybe the I use experience. I don't know. Yes, they do. Honestly. Yeah. So, after my friend engaged me, I went to my friend engaged me. I went to ask for documents. So we documents. So we went to the general room. Excuse para ko na siya. I keep sa na. Then yung representation is zero na ko hindi siya. Well, representation na natin. Ang dito ko sa mga dito. Wait na lang. You should replace my representation. No, in my representation, I mentioned that I nursed the documents. I think I'm going to do it. It is supposed to be on 13th January. Huh? Jadinya for January lagi. For January.
No, not.
Yes, ma'am. What was the citation? You were,
Your Lordship, that's the book.
oh,
It's kept, Your Lordship.
this
Yes,
book.
Your Lordship. 2013 for SSC.
Just wait, okay. 2013 for SSC 531.
There are relevant paragraph would be 13 and 17.
Just wait. Para 13 and 17, correct? Para 13 and 17. Got it, right? Yes. 13, 17. Kindly read.
Which I would like to read 13, 16 and 16 also, Your Lordship.
13, 16 and 13, 16 and 17. And 14 is with regard to non-application of mine. I think this is also relevant. Okay, kindly read.
Yes, I'll start on para 13.
Yes, yes.
In a series of decisions, this court has held that it is the subjective satisfaction of the detaining authority whether a person has to be detained for a particular period of time or not. In the impugned grounds of detention, the detaining authority has narrated all the reasons for passing the detention order, detaining the appellant with a view to prevent him from abetting the smuggling of goods in future.
Correct.
Para 14. With regard to non-application of mine, Mr. K.K. Mani, learned counsel for the appellant, pointed out that on the date of passing such and such, the detainee was in prison, though he was granted bail on such and such. He had not availed the same and continued in prison on the date of the order. According to him, this aspect was not reflected in the detention order, which according to him vitiates the detention on the principle of non-application of mine. It is true that though the detainee was granted bail on such and such. For
Yeah,
the
this is
reason-
not relevant.
Yeah.
Yes.
Yes, Your Lordship, that's why, Your Lordship.
16.
I would like to, yes, 13, 16, and 17, Your Lordship.
Ah.
It is clear that if a person concerned is in custody and there is no imminent possibility of his being released, the rule is that the power of preventive detention should not be exercised. In the case on hand, it is not in dispute that in such and such itself, the competent authority has granted bail, but the appellant did not avail such benefit. In other words, on the date such and such, by virtue of the other granting bail such and such, it would be possible for the detainee to come out without any difficulty. In such circumstances, while reiterating the principle of this court enunciated in the above decision in the Binod Singh case, and in view of the fact that the detainee was having the order of bail in his hand, it is presumed that at any moment it would be possible for him to come out and indulge in prejudicial activities. Hence, the said decision is not helpful to the case of the appellant. In view of the above circumstances and of the fact that the detaining authority was aware of the grant of bail and clearly stated the same in the grounds of detention, we reject the contra arguments made by the learned counsel for the appellant. On the other hand, we hold that the detaining authority was conscious of all relevant aspects and passed the impugned order of detention in order to prevent the appellant from abetting the smuggling of goods in future. For the same reason, the other contention, namely that there is no compelling necessity to pass the order of detention, is to be rejected. As a matter of fact, the learned counsel for the detaining authority took us through various grounds, details, materials adverted to in the impugned order, and we are satisfied that it cannot be claimed that there was no compelling necessity to pass the order of detention. We have already pointed out that it is the subjective satisfaction of the detaining authority whether the order of detention is to be invoked or not. Accordingly, we reject the above contention also, Your Lordship. Your Lordship, in the detention order, Lord, we have clearly mentioned in paragraph 4, Your Lordship.
Take us to the.
Yes, Your Lordship. Yeah. Page 18, annexure A, Your Lordship.
Of your affidavit?
Yes, my
Page,
page 18, annexure A.
annexure, page 18. This is just wait, okay? Page 18.
Para 4, Your Lordship.
Just here the grounds. Yes, please.
Para 4.
Para 4, just.
That you are presently under judicial custody. On the basis of the material placed before me, I am satisfied that you are likely to indulge in similar prejudicial activities unless you are prevented from doing so by an appropriate order of prevention, Your Lordship. So, Your Lordship, the sole object was to prevent him from indulging in prejudicial activities, Your Lordship. Therefore, Your Lordship, the submission that the detainee was in judicial custody without filing any bail cannot be a ground, Your Lordship. It can otherwise validly pass on the subjective satisfaction to the detaining authority, Your Lordship. Your Lordship, these are my submission, Your Lordship. I raise and pass, Your Lordship.
Is any reply?
Your Honor.
Hmm.
Yes, sir. I want to give it 2 minutes.
Yes, you are given more than 2 minutes.
In an affidavit in opposition.
Of the government.
Yes. And para 20.
In para
20.
20.
Para 20.
Yes, wait. Yes.
Page number 9. Para 20 page number 9. The last para. Page number 9. Last para. The same was disposed of by the central government on 30/01/2025. Annexure X. Annexure H. My lord, Annexure H is page number 27. I am of the opinion that this cannot be disposed by the central government. Page Annexure.
Your Lordship, my Annexure H is the receipt of the speed post and speed post, Your Lordship.
By advisory board. Or
No, the central jail authorities had sent the representation to the central government, Your Lordship. The representation, this is the receipt of the representation which was submitted to the advisory board, Minister of Finance, and this government, state government, Your Lordship.
so advisory board received on 11/1/2025, correct? And Ministry of Finance received on 11/1/2025. And what is this Lakhandas and Apot Sheba? What is this?
Those are other
There's
cases.
another detainee, Your Lordship. Afot Chepa is the present detainee, Your Lordship.
So your relevance here is page 27 is 1 and 3. 1 and 3. Advisory board, where actually on the side you have written advisory board and on the side you have written Ministry of Finance.
And even the third one, Your Lordship, was sent to the Chief Secretary, Your Lordship.
This is Lakhandas.
No, the Afot Chepa is the detainee in the present case. Your Lordship. So they were sent together, Your Lordship. Maybe, Your Lordship, the representation.
This is to the Joint Secretary. We don't find anything about the Chief Secretary. Or to the Special Secretary, but to the Chief Secretary, okay. And this is also received on? You have not given any date. The joint.
Your Lordship, with my paragraph, the relevance is with regard to the sending it to the advisory board and the central government, Your Lordship. I make the statement only on those two, Your Lordship.
This representation 11/1/25 was disposed of by the central government on 30/1/2025.
Annexure X.
Is it so?
The petitioner had annexed it in the writ petition, Your Lordship.
Yes, Your Honor.
It's in the writ petition, Your Lordship.
Okay.
Affidavit in opposition, Annexure X. The petition, the paragraphs in the annexure does not tally. It must be.
This annexure H was inadvertently included in the petition, Your
Yes,
Lordship.
if that means that is all.
Yeah, that was inadvertently added, Your Lordship.
Yes.
Your Honor, I would like to state that the documents which has been exhibited by my learned counsel are reading from page number 119 to 223.
The records.
Yeah, records. Those documents has to be with me. That's all the while I'm stating that. Those documents which they have exhibited has to be with me also.
These are the second copies where the detainee has signed.
Yes.
The first copy is with the detainee.
Yes.
And if the detainee does not give you, whose fault is it? Because actually the government has supplied. That is why from the very beginning I was telling you whether you will have any affidavit filed against the affidavit in opposition by the state respondents.
Then, Your Honor, Then we've inquired us again and again as a council about this.
We cannot go by your submission, Mr.
Okay.
Council. We cannot
Then,
go by your
but-
submission.
then I,
We go by records.
okay, then, Your Honor, if by the records, I have written representation to the government,
Huh,
to the authority, stating that I have not received the documents.
huh.
Then they have not replied, or they have not replied, or they have not addressed.
No,
the-
your signature is very well there stating that receipt. We are not going to accept that submission.
Honorable,
That is your own submission.
Okay, Your
That is your own submission. We are not going to accept that. We go by records.
Then when my representation was disposed, the issue was not addressed in the orders.
Huh.
When my representation was addressed by the special secretary home, by the chief secretary and other authorities, they have not stated that they have issued the documents to me. It was never addressed.
There's a proof. The records are there. There is proof. You are just trying to divert your submission by making some thing which is not relevant. We go by records because records are very clear. Record shows that this Apot has received all the documents. And he has signed it.
Yes,
He has signed it on 28/20/24.
that's my submission, Your Honor. Documents I was made to sign, but it was not handed over to me.
Okay,
That's
that's
why I
fine.
have written in my representation, but when my representation, it was never addressed. It was never addressed.
Okay, anything more?
Your Honor, that's it.
Any questions to us? Okay.
And what about this?
Central government,
Yes, my lord, I have submitted this before. We have received a representative from the branch of the detainee for revocations of detention order on 10th of January 2025. And after receiving that detention order, representation for revocations of detention order, my lord, we have acted upon the reference of the detainee out of promptitude. And thereafter, we have asking Barawai's comments from the state government. And after receiving that Barawai's comments from the state government, we have acted upon that representation, and there is no material on record to interfere with the detention order.
where is
So
your
accordingly,
affidavit?
we dispose.
Where is your affidavit?
I know I filed on 9/4/2025.
9/4, let us see. 9/4, okay, affidavit on behalf of respondent number 4. What have you stated?
Relevant portion is my lord, sub-para 4 or paragraph 2, my lord. Page number 3.
Para 4.
Yes, para 4. Which we have received the representation submitted by the.
Sub para 4 of para 1.
No, my lord, para 2.
Oh, para 2, okay.
And paragraph 8 is Barawai's comment received from the state of detainee authority by law. But that one is 17 January 2025. And then thereafter, the paragraph 9, that one is 20 January 2025, which the advisory board has confirming the detention order. After considering all these facts, my lord, there is no material on record to interfere with the detention order passed by the state responding my lord. And we have received the representations of the detention, representation of detainee on 30 January 2025. And that one is communicated to the detainee as well as the central jail. And through that transition process, communicated to the detainee. Page 7 is permissions of receive a copy of the letter delivered to Sri Abu Sipa PDB Stadium for Central Jail. And this one is if breaking the day. Self of the territory, and that memorandum, which one is passed on 31 2025 is page 85.
So the detention order passed by the government on 17/8/2024 was received by the central government on 27/8/2024. 413. This time, the central government. Any inquiry? Inquiry? Yes, anything more? Heard. Mr. So-and-so. Learned counsel for the petitioner. MS. Inauli. The learned government advocate for the respondent number 1, 2, and 3. And Mr. Zaten Muli. Learned counsel, learned CGC. For the respondent number 4. But the parties at length, judgment and order reserved. Your Honor. Give this with part 2, okay? And part 1, you give in part 2 with this record, you give me part 1. You will just have a list. Yes. Okay. We're not again. For admission, item number 5.
Mayor, please, Lordships.
Yes.
I pray that this matter will be adjourned for 2 weeks as my senior associate counsel Jamir is out of station.
We are here for this case.
Lordship, on 22/2/2025, this honorable court has even observed that cost, there will be cost if more time is sought.
Pay cost.
Sir, Your Lordship, so the matter appeared on 303.
That, yes, we have seen that.
Need to take it up, Your Lordship, on that particular day, but it was not taken up because the Lordship was, Your Lordship, the LS Junior.
No, because we know that it will not be taken up because it was placed before Lordship Devashish and his order was annexed in the writ petition. That's why for that it was not taken up.
That was at your instance. We wanted to give it a later date. You said we will have a try with Justice Devashish.
Yeah.
That was your submission.
Ye-
So that is why we have listed it, knowing fully well that
Okay.
Justice Devashish may not be able to take up the issue on your instance.
No, Lordship, in fact, I said that it may not be able to be taken up by Dr. Lordship Devashish,
No.
but this honorable court was
You
of
wanted to take a chance. So what do we do today? We'll list it next week. Tell him to come next
on
week.
23. Yes.
And then we say that if the matter will not be taken up, then we'll impose cost.
All right, Your Lordship.
If not, we are here for this case today.
Lordship, we are fully prepared. Lordship, it may not
If,
go, unfortunately, they
if,
will not go on like this.
If this court was there, we could have heard the counsel for the appellant. And next week we could have heard you. But brother and myself, we are sitting only for this week.
In fact, this is maybe Lordship, this postponement is because there is status quo and that is the reason why it has been postponed, though there is a.
Where is that status quo? Status quo, in fact, status quo is in your favor. That means
No.
to maintain that position as ordered by the learned single judge.
But on the other hand, they are thinking that since they are in service, they are maintaining status quo,
No,
they
they-
will continue it
they
for
should not.
even a year.
They should
That is their
not.
perspective. That's why they have been postponing up to this extent, Lordship. Otherwise, on 21/1/25 itself, the Honorable Supreme Court has already, as similar matter already dismissed the case, the constable's case. So this case is covered by that case. There is no, this is not an isolated case.
I know.
Yes, Lordship, and because of this,
But where is that status quo order? By which order?
first
Which order? Let us see.
status quo order will be when it came up for motion, Lordship.
The motion, I think there was no status quo.
Status quo, Lordship.
Which order?
27/11.
27? 27 October?
When there is a direction, yes.
No, which order? Which order, ma'am?
And this case is continued.
I have not seen that order. Till 13/11? No.
Prior to that.
This is
I think this.
This is the first order.
Hmm.
1610.
No, not there, I think, yeah. Thereafter, I think, just maybe. Oh, sorry. Commit yourself. Thereafter, obviously, because it was continued thereafter.
So which order?
if I remember correctly, Lordship, there is, and this.
There's no status quo.
No, yeah, yeah. Maintain status quo is needed.
Which order?
Your lordship, by the order dated
13,
16/11/2024.
Considering all these aspects, we direct the parties to meet the status of the present date. This is the next. Yeah, next. So this was.
Which is that one?
Continue this.
13, 13, 11.
Yes. Last page, last page.
We'll impose cost today. We are imposing cost 20,000.
You looked at the matter and we take it.
No. We are imposing cost. And on the next day, the next week, if the learned council does not appear, we vacate the status quo. How can this be? Every time the matter.
One of his relative fell ill yesterday, so he had to go urgently in lordship. I sincerely apologize on behalf of my senior lordship. We'll take up this matter in the lordship will be positively present.
Madam so learned counsel for the appellant. Commas. Mrs. MS Zajimomi, learned counsel for the respondent number 5220. Mr. Mr. LT Sanctum, learned additional AG for the respondent number 1 and any more? And Mr. TB Jamir, learned counsel for the respondent number 225.
6 to 20, Lordship.
6 to 20, Ms. Zajimomi. MS so-and-so. Learned counsel for the appellant submits that the leading counsel, Mr. Siti Jamir, learned senior counsel, has to attend to a sick relative and is therefore unable to give his presence for the case today. and 6 for a short date, and 6 adjournment of the case for a short date. MS Z. Jimomi, the learned counsel for the respondent number 6 to 20, has vehemently objected to the prayer for adjournment sought by the learned counsel for the appellant. Stop. Having heard the learned counsel for the parties, the matter stands adjourned for hearing on 23/5/23/4/2025. It is made clear that there shall be no further adjournment, and any adjournment shall be subject to cost. Subject to cost. Kindly tell him to appear. Just, I wanted to impose a cost of 20,000 at least today. But since he is attending to a sick relative, okay, maybe on the ground. Listed account. Orders, item number 6. Yes. who
May
is
I please, my lords. Am I audible, my lords?
Notice issued upon respondent 2, 5, and 6 has been returned unserved from the post office. Meanwhile, the return service report upon respondent number 1, 3, 4, and 7 is awaited. Anyone appearing?
My lords, I am appearing on behalf of petitioner, my lords.
Yes. Notice upon respondent number 2, 5, and 6. Returned unserved.
My lords, we can serve it, we can serve them by email, my lords.
Is there any possibility to take to serve notice by Dusty? Anyone
My
is-
lords, I have to ask my lords the council, actually, he is not in court today. The council, which is usually there.
Your Lordship, in this matter, I am the standing
Mr.
counsel for CDIC.
Huh.
However, they have not served copy through me and it has gone through the registry.
Okay.
I can accept notice.
You
of-
are for.
I'm for all the respondents.
All the respondents.
Yes, I
Okay,
can
very
represent
good.
all the respondents.
Okay.
I can serve him through email, my
You,
lords.
you serve copies. You serve copies.
My lords, I will take.
All the respondents.
Yes, Lordship. One copy may be enough, since they have taken steps through the registered ADR. 2 copies may be enough.
Okay. You serve 2 copies of the petition to the learned counsel for the respondents. Okay,
Okay, my lords.
Mr. Your good name? No, your good name?
Ketan Jain, my lords.
Mr. So and so. Got it? Nitin, your good name?
Ketan Jain, my lords. Ketan Jain.
Mr.
Ketan Jain.
Mr. Ketan Jain, learned counsel for the petitioner, shall serve 2 copies of the writ petition to Mr. Zat Kunnu. When?
My lords, within 2 weeks' time, my lords.
Within a period of 14 days from today. Listed after 4 weeks.
Lords, there is my interim prayer, my lords.
No. Interim prayer shall be considered on the next returnable date. Okay.
Thank you. Obliged, my lords.